What's up, everybody? Welcome back into another hearing with Sarah Boone. So many of you told me this was happening at the time. I was able to watch it over the weekend, and it was interesting. We get to see her arguing, her winning some motions, her making some arguments, some good, some bad, some indifferent, but we get our first inclination as to how people get steamrolled when they are representing themselves. Things happen in this hearing that would not happen if she had a lawyer. It is fundamentally unfair, but nobody says anything about it. It seems completely normal. Everybody just keeps going along. She makes some comments that make you think, yeah, this is actually unfair. So that's just a little taste of, I think, what's going to happen between now and the trial, and then during the trial itself. Let me know if you guys think it's unfair as we watch this together. Make sure you subscribe. Make sure you hit the like button. Let's get into this hearing. All right. What's up, everybody? I see everyone in the chat saying hello. It's Monday. Things are great. We've got another week of opportunities to help people to do good, to learn and grow. And hopefully this is an opportunity to do that. As we sit here, we watch this, we learn from it, and we see how it works here in Florida for a pro se defendant, especially one that did not want to be pro se on her own, as she will continue to remind us and the court. So we're here today for some of the motions that she's already filed to actually have hearings and oral argument. And the judge is going to make some decisions. And there's a lot happening that some of it gets explained to her, some of it doesn't. That's going to be one of the more interesting parts of this hearing to me. And then, of course, we get to see and hear what she says, which is always interesting. So let's start out. I skipped the beginning, which was just some logistics, procedural things, and we're going to get into the meat of the hearing now.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice.
Okay.
But I can't tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We had this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Boone Lane, Chief Investigator, Owner, Prison Break Investigation.
Okay. I understand part of the order from Monday was regarding the state's digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to that first. So either Mr. J or Mr. Cashmore.
Yes, Your Honor. We have tendered to Mr. Lane.
This first thing they're talking about is the state's digital evidence. So this is a different thumb drive, different than the documents. This is the digital evidence. I think there's 9 pieces. I can't remember now. It's been a couple days since I listened to this, but there's like 9 pieces of digital evidence that they are planning to use at trial. They took them out of the discovery they've already given her, right? So they gave her a mass amount of discovery. But now they're taking it out, paring it down, specifying these are the 9 pieces we expect to use at trial. They include, as you would expect, cell phone videos and things of that like. So this is a separate thing that they've given to Mr. Lane so that he can watch with Sarah Boone and discuss exactly what is happening with the evidence that's going to be presented at trial.
A copy of our the exhibit list with our expected items of evidence that will be received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness list, also proposed jury instructions, and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right. The witness
Stipulation of victim ID just means we're going to stipulate that the victim is who he is, so they don't have to prove that in front of the jury.
an exhibit list that is included on that USB. Do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question. Okay.
I have a copy for defense.
Okay, very good.
Also unusual to file the witness list in open court, but it actually just makes it easier and quicker to give it to her right here, so they don't have to go through the process of filing, mailing it, sending it to her. She can have it. Everybody knows she got it, so she's not going to complain about that. It also goes to the court and into the file.
If we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
And Your Honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way the witness lists are routinely sealed. A copy of that request is sealed is there with the notice of the witness list on the initial page before our notice of the exhibit list.
What I have in front of me is the notice of provision of witness list, and then the notice of expected evidence and witnesses in trial. I don't have an order. Or
It wouldn't be an order. It would just be that first document you read, reference to notice of provision of witness list.
got it. Okay, thank you. All right.
So the state is asking for the witness and exhibit list to be sealed, meaning from the public. And my guess is Sarah Boone's going to be on board with that because that's been a big fight of hers, is to keep as much out of the YouTube sphere as she possibly can and keep the media out of her way.
Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own.
All right. So for our daily reminder, if it's too fast, you can hit this gearbox on or this gear icon on your video, and you can slow it down to whatever you want. Okay. We'll bump it down to 125. That's about as slow as I can go because I really want to watch this entire hour of the hearing.
Understanding there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone.
Yes, they're broken down by folders.
And the folders, or the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to suitcase, videos, and still show.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well that Mr. Lane has had an opportunity to copy for his client that I can tender to either tender to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right. Ma'am, or Mr. Castro, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, Your Honor.
Okay. Ma'am, have you had the opportunity to review the notice of expected evidence and witnesses and trial document that was just provided to the court and yourself this morning?
I did.
Okay. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Good question and good point. Haven't seen it, so I don't know if I have any objections. So she's not going to waive any objections. And number 2, she's like, did I already get this? Is this additional? Or is this the same thing I already have, just pared down? So great question. Diva Dawn said, Peter, I sent you an email today about a case. Okay, I'll have to take a look at it. I don't know if it's a personal, like real case, because for anybody new here, we do practice law at my firm, mostly personal injury, wrongful death cases, trucking accidents, car accidents. So feel free to email me if you guys or someone you know has a case like that. Love to take a look at it for them. If you're talking about a case to cover, please let me know. We're still looking for what's next, and you guys choose the content. Will's mom, Peter, as of right now, even if she had a good defense lawyer, do you think she has any chance of getting off? Just wondering what your opinion is. So any chance at getting off? Yes. A good chance at getting off? Maybe not, but I don't know everything about the case, right? I'd have to look at all the evidence and really dig into it. A good defense attorney would have some to work with on this case. At the very least, I think she would have a good chance of ending up with a lesser included and not second degree, which is the highest charge I believe that she's looking at. So I do think she would have at least a good chance of a lesser included instead of the highest level charge if she had a good defense attorney.
Also,
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay. Any other questions? Yes.
yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files. So I cannot open a majority of what are on both of the USB drives.
What do you?
So one good thing, one bad thing. Absolutely agree with her. Happens all the time. The state will give us documents and files. They don't even know what's on some of them. They don't work. You can't open it. You don't have programs on your computer to open it. All sorts of issues like that happen. So no big deal. The problem with what she said is she said, I can't open a majority of the documents, which is not usually the case. And the judge is going to dig in on that a little bit. So again, when you're a lawyer or Sarah Boone acting as your own lawyer, you've got to make sure what you're saying is true and you can build credibility, even as a criminal defendant. If what you're saying is true and the judge knows this and the prosecutor knows this, that sometimes files don't open. But when you say a majority, now you're trying to overplay your hand.
I mean, you cannot open a majority. What can you not open?
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats, but there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay,
So I don't
what does
know.
it say?
I don't know. I moved on from that to try to go to other programs. So I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now, that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. And that's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Okay. And how many times has that happened?
The ones
One
that
file, 10 files, 20 files, 50 files, or is it just a one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had.
I don't know what for the most part means.
I haven't had time yet to explore everything.
See, she's like backtracking a little. The judge is pinning her down. He's doing a good job cross-examining her basically about her issues. I like it. I like how he's handling this.
Due to the dorm environment. So as soon as the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you. So you know what I'm trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
All right. Dave?
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she clicks on that folder, she can click again on a subfolder, and she will find the VLC files for where the Publix video has been converted. So everything.
So again, I'm just guessing at what the Publix video is. Probably her going and buying the wine there. Not positive, but.
And there should be standard JPEG, VLC, and also believe an MP4 or some audio-only files.
Okay. All right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided the court and yourself this morning?
That was what was just handed to Mr. Lane. So Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure. Okay. State, anything else we need to talk about with regard to that issue?
Not in regards to that issue.
Okay. All right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning, and you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? About approximately what time are you going to be meeting with her? If you know?
9 a.m.
Okay. All right. I have had the opportunity to have further conversations with Major Mohammed at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the
That sounds like impeachment. It's like, well, now we're a little confused. Ms. Boone, have you told somebody that you have everything you need and you're good to go?
sergeants came and spoke to me yesterday, miscommunication of some sort where I explained to her what I'm trying to do with purging my property in the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, Hall, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you. Do you know Ms. Hall's first name?
I don't know any of the officers.
Okay, all right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously, and Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me.
Mad Marsha, yeah, I noticed that too. It's like, was that Tracy Hall? No. It was Miss Hall. It's like, do you know her first name? No. It's probably Tracy Hall.
Ask this. State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No, Your Honor.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June.
So Bella, the interesting twist on this, I agree with you, but she requested a laptop multiple times and said it was unfair that she doesn't have access to a computer in her letters that we've reviewed. And that's why the judge went laptop, because Sarah Boone made it seem like she didn't have anywhere to put the documents and she wanted a laptop. So he thought he was giving her what she wanted. When he found out she wanted the hard copies instead of the laptop, or in addition to, now he's trying to work on getting her the hard copies and a laptop. So they're doing everything they can to get her the documents and the discovery.
June 28th, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Copsall and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
Okay, were they a part of the 2 USB drives that we addressed on August 5? You have the smaller one, which was everything you digitized from the 2 boxes, and then you have the larger one of other materials that you had been given previously.
No, but I do have a drive that I can put them on and make sure they get to the jail today.
Okay, if you could make sure, sir, that when you drop off the other 2 things, digital copies, I know Ms. Boone has identified that she has physical copies, but I'd like to give her digital copies just in case. State, do you have any questions with regard to the court's directive to Mr. Lane regarding the hard copies, depositions of the detectives, or the digital evidence the state may seek to admit in trial?
No, Your Honor.
All right. Ma'am, do you have any questions for Mr. Lane regarding those 3 items?
No.
Okay. Can Mr. Lane be released?
Yes.
Okay. If you want to, can he be released, ma'am?
I guess I'll see you at 9.
Okay. So if you could endeavor to do that today. All right. Then defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled.
All right, so here we go. Now it is the removal of shackles and handcuffs. And there's also interesting things that happen here. This is the most interesting part of the hearing to me.
Shackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand filed with the court on August 5, 2024. Court has had the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion, and we have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay.
So it's a bit of an eye roll to me for them to oppose the motion, but we've seen stuff happen in court. We've seen safety issues. We've seen people get hurt. So you can't really blame them for opposing the motion, I guess. I don't think I would have, knowing her background and what we know about her case and knowing what the corporal's about to testify to here. But here's the major problem, okay? Here's the first and big problem I see with the state. If I filed this motion as a criminal defense attorney and the state had an objection to it, they would have to file that objection prior to a hearing. They would have to let me know what that objection is. I could respond with that objection. If they're going to call a witness, they usually have to let the other side know that they're going to call that witness so that I can prepare to also ask that witness questions. Sometimes they would even have to go as far as to say, my objection is X, and this witness is going to come testify to X. So if X isn't true, or I have documents to prove that X is not true, I can prepare those documents, give them to the court, and win my motion and my argument. Because a lot of times judges won't let you have 2, 3, 4 hearings on the same issue. But guess what? It seems like, I don't know, I haven't seen it, that they didn't file this objection. They didn't file anything to say they're going to call this witness. They didn't put Sarah Boone on any notice that they were going to call a witness, object to this, and have this all happen in the hearing, as opposed to just oral argument with case law and statutes and rules and other cases and whatever they want to do. So I found that very interesting and telling, that they have an objection, call a witness, didn't put her on notice, and she has major problems and arguments with what this witness has to testify to, and she says she has things that can contradict that. Is it true? I don't know. But Brandy, that's a great point. This is why you do not represent yourself. Is it unfair? Not really, right? If this is how it's going to go, this is how it's going to go. It's very different when you represent yourself. But Brandy's making a great point. This is why you don't represent yourself, because the state's not even trying to railroad her, and they're railroading her.
So, ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions. We'll cross-examine him after the state's concluded asking any questions. Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay.
Do you have any questions about?
She didn't even know what was happening today. And again, fundamentally, I believe that's unfair. But they're also hurrying or rushing or expediting the process, giving her hearings one right after the other. They have another hearing that they're going to keep because they're just going to keep doing stuff and keep moving this case along. So I can't blame them. You can't have your cake and eat it too. If you want this stuff to move quick, sometimes stuff like this happens. And he probably would tell a defense attorney that. Well, if you want to delay it, we're going to trial this day. So if your client really wants to be unshackled, we can have the hearing now, or we can wait a couple weeks and have it then. She would probably say, let's do it now.
About that process.
I don't.
Okay. All right. Let's go ahead and call your witness. State.
State will call Gavin Wilson.
Sir, good morning. Can you state you may proceed?
I work for the Orange County Sheriff's Office as a deputy sheriff.
And to what area
So they're calling a cop here to basically talk about why they don't think Sarah Boone should be uncuffed and unshackled.
of the sheriff's office are you assigned?
Court of security.
And how long have you worked that assignment?
4 or 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And are you familiar with the defendant in this particular case?
Just through research that I've done on her, I don't have any personal knowledge.
And what
That's interesting. He has no firsthand knowledge about the defendant. I'd be like, I'm not so sure he should be testifying to some of this then, but everything he's testifying to is basically document, public record type of stuff.
in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge, second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate.
So the charge, serious, we knew that. Prior arrests, okay, not convictions, but arrests of domestic violence. And this is why, and I just want to pause here. It's appropriate for him to bring that up. And if she has some of these violent accusations in the past, what is she capable of? Courtroom safety, things like that. But for anybody that thinks it's no big deal when somebody accuses somebody of a crime or somebody gets arrested, oh, the charges got dropped, no big deal. Or even somebody that goes to trial and gets acquitted with a not guilty verdict. It's like, oh, yay, they won. It's like, yeah, but that stuff literally follows you forever. Your life can be ruined with arrests or charges, even if they lead to drop charges, even if they lead to not guilty verdicts. And the state law enforcement, they will use it against you every chance they get. They'll treat you like a criminal, even though she was not convicted of those domestic violence crimes, and she hasn't been convicted of this yet. So just know that that's how it works. That's how serious it is. That's why we have to take presumed innocent until proven guilty. We have to take that seriously. And they're about to say, oh, yeah, we all know why that stuff got dropped. It's like, oh, so we're just still going to hold it against her as a conviction. Now, luckily, we have a judge, and he's a fair judge. And the state and law enforcement, they are not there for you. They don't care about your rights once you've been arrested, for the most part. They are trying to go a certain way. And they're going to use this stuff that I find to be totally irrelevant or that should not take precedent when you balance it with the fact that she has to represent herself. She's got to be able to write. She's got to be able to hand stuff to people. She's got to be able to move somewhat to represent herself. There are a million other things you can do to make sure that there is courtroom safety, and that has to be important. But where is the line? And to keep her cuffed and shackled because she's been arrested in the past and because of what she's charged with. And I'll just tell you, listen, it's not good to get arrested, not good to be in the situation she's in, especially with all the evidence against her and probable cause against her and enough to keep her in there with a high bail amount. I'm not saying there's nothing against her, that she's never done anything wrong. I'm not saying that. But in comparison to how the laws are written, the statutes are written, and how we balance this stuff, she doesn't have enough, in my opinion, of a security risk to be cuffed and shackled at counsel table while she represents herself. Just my opinion.
Instance at the jail for non-compliance, where she was told to attend her court hearings or scheduled court hearings, and she refused to do so. And then even when the
So then we have a couple times where she was non-compliant and didn't attend her court hearings. She's going to argue with this. I had people reach out to me. They're like, I know Sarah Boone, that's not true. Say something. I don't know whether it's true or not. He has some corroboration. She does fight it a little bit. It would have been nice if she was on notice and if she actually had documentation of this that could have proven what he was saying is wrong. Would have been nice to allow her to produce it, but we didn't get that opportunity here. But what I'll say is her missing court dates, what does that have to do with courtroom safety? She's not going to flee when she's in court and they take her cuffs off. They're not going to uncuff her in jail. They're not going to uncuff her for transport just while she's sitting in court working as a lawyer. So like flight risk is not a real risk here. Come on. It's more about safety. And so her non-compliance with prior hearings, if that's even true, to me, doesn't have anything to do with safety.
corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you can combine all that, I mean, it shows propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
So she's shown a propensity for violence and that she's not going to comply with lawful demands. I'm sorry. I know you guys have your thoughts about Sarah Boone. She's not my favorite person we've ever covered or defendant we've ever covered. I think she has dug herself a serious hole. I think the judge has been right in saying that she's waived her right to counsel. She's blown it. She's been condescending. She's been disrespectful. She has put herself in this situation that now we're seeing how just impossible this is. But come on. I think they're overstepping, in my opinion, saying that that she doesn't comply with lawful orders and is a danger, risk of physical harm to people in the courtroom.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Logan?
I do.
Go ahead.
First,
So before we get to her questions, we know she disagrees with a lot of what he said. Brooks was handcuffed, wasn't he? So his hands were not, but his feet, I believe, were shackled to the floor. She's pretty tiny, put an extra officer in court. We'll see the protocol they end up coming up with that I personally think is perfect. I think it's a great decision by the judge. Well, you'll be in the courtroom with her, Peter. Yes. And I'm perfectly comfortable with what the judge decided. Perfectly comfortable with it, even after hearing what this officer had to testify to. Rack V thoughts on her phone line request, the audacity. So I'll give you my thoughts when I get there. But I do think that there should be certain benefits, I don't know if that's the right word, given to somebody that's representing themselves so that they at least have the best, worst chance at possible good representation.
First off, in your inputs research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that.
He was, but he doesn't care. And she makes a good point, but he doesn't care. Luckily, though, we have a good judge who's listening to all of this. So even though it's all coming out, I think he only looked at and considered what was appropriate and balanced it appropriately, which is why when you have a good judge, some of the annoying stuff law enforcement does or tries to press on or the state attorney does, if you have a good judge, you don't fear that stuff as much. If you have a judge that just always agrees with the prosecutor, that's when you're like, this sucks. There's nothing anybody can do to make sure this is a fair courtroom.
Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued. I've never hesitated.
Objects to the form of the question, Your Honor.
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
Okay.
I am prepared to give her.
And I actually think these hearings are good for her because she's going to learn the objection process. She asked what does sustain mean at some point, but she's going to start to learn how to ask questions. Again, the state objecting is a total eye roll. It's like, what are you afraid of? You've got a professional witness up there, a professional law enforcement officer. Sarah Boone shouldn't be able to outsmart him with her questions. Just answer her questions, have a conversation. But I think it's actually good for her that he's objecting and she's going to learn the process a little bit before it happens in front of a jury.
Yeah. On September 15, 2023, that was one of the times we refused to attend. October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in
At
court?
the jail, yes.
Who is your contact, please? I've never missed a date.
This is the database that I got this information from.
Do you know when it was last updated?
This, I don't know.
Okay, so do you know how I have never missed a court date to the present date? I don't know specifically what these 3 dates are for in order for me to have supposedly
By the way, in case anybody's wondering, everything she says in these questions can be used against her.
denied going. Do you know the name of the officers for each one? You do? Please.
Because she's asking a question, but if she's making a statement, she's making a statement. So now they're going to get into some of the details of these missed court dates. That may or may not be true. But the point is, she didn't get the opportunity to prepare a response or bring documents to impeach him.
For September 15, 2023, it is Corrections Officer Portia Hines,
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay,
And if you would like, I can read her comments in her report.
sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say.
They were talking to her at midnight. I think that's kind of interesting. And she refused to go to court. Okay. These notes that are in the record, they do give credence to it, to me. That's why I said, if she had something, I would have liked to hear it. If she didn't, then she loses. Well, she doesn't really lose. She loses this argument. She doesn't lose this motion.
What it was that I supposedly refused.
To attend court. It doesn't say specifically what your hearing is for.
Okay,
Second one,
So, Rena, the reason they're trying to say this matters is they're trying to show this as evidence that she doesn't comply with lawful orders. It's like, okay.
it'll be Officer Christy Green.
and what is this date for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's going to be October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
And what was the first initial, please?
K.
Greene,
Yes.
10/16/23.
Yes.
Okay,
And the third one is January 28, 2021. And the officer is Jasmine Scribner, Scribner.
What are the comments, please, for Green?
At approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward at the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay. And January 28th?
Approximately 0334 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information down.
Okay, so I'm trying to figure out how I know all three corporals and the sergeant, so I've never refused court. There's no reason for me to want to refuse court.
I'm going to object this to ask and answer.
I'm going to sustain the objection.
So the domestic violence, the original, was dropped. I was never charged with that.
Object is the relevance, Your Honor.
Overruled.
As to relevance, I mean, if you're going to bring up the arrest, the charges being dropped or of her being convicted, that's very relevant.
You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate. So they probably didn't have information to go forward.
So he gives his expert opinion that, well, they probably had everything they needed, or they just probably didn't have everything they needed, or somebody didn't cooperate. That's why they dropped the charges. Not because you didn't commit the crime. No. That can't be it. That can't be the reason why, right? But we don't know. And that's the point of charges dropped. The state and law enforcement, they don't get to say what happened because they didn't prove it beyond a reasonable doubt. So they don't get to say you committed a crime if you didn't get convicted or plead guilty to that crime. But yet, that's exactly what he tries to do. And he tries to say, oh, the only reason you weren't convicted is because somebody didn't cooperate. Where there could have been a million reasons why she wasn't convicted or why charges were dropped.
With the charges, that does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
The state didn't have a case they felt like they could win. It's like, so that doesn't mean you didn't commit the act. Well, it doesn't mean I did commit it, right? Legally speaking, it very clearly means it does not mean I did it.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
Your
It's
Honor, Your Honor, I'm going to object to the question.
Objection sustained.
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm going to
So again, now she's testifying, which is dangerous. She's giving the reasons why, which don't really sound great for her either. But regardless, no conviction.
object this to the form of the question. It's not a question, it's a statement.
Sustained.
Forgive me because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way, apparently. So I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand your position. I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing
We could have provided her notice that this was going to be the argument made against her freely moving about the courtroom.
my best with being uneducated in this situation. That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that is in your history.
I understand, but I was never charged with it, correct?
You were charged with it. It was dropped. The charges were dropped.
But it is not on my record.
The rest is on your record.
But the charge for,
He's right. She's asking the wrong questions. This is all public. It's on her record. You can see these arrests. She's just using the wrong language. She should just go with weren't convicted. It's not the conviction is not on my record, things like that. I don't know if she's been convicted of other things. I think she has. So she can't ask questions like, I have no convictions on my record, things like that.
The domestic violence is not on my record.
No, you were never
Object is to
convicted.
ask and answer, Your Honor.
Overruled.
You were never convicted of the domestic battery charge, but you were charged with it.
And the case was dropped.
Yes.
For the three supposed non-compliance that I have, I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it
Your
a,
Honor, I'm going to object to the form of the question. This is a statement, not a question.
Objection is sustained.
I guess I will provide information to you for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to, that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
What do I need to provide to you in order to have that remedied, in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
And again, it doesn't need to be provided to the officer. It needs to be provided to the judge because the judge is making the decision. The officer is just giving her his opinion, but she's trying to convince the officer that she's not a danger, things like that.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's that?
The decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Right, but just to clarify and conclude, I was not ever charged with that.
Again, I'm going to object as to ask and answer.
Sustained.
Okay, I will, do I provide this information to you?
You can provide it to the state.
Flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraint.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018?
Correct.
And it is now 2024.
It's very strange to watch because it's like, it's as if she's not talking about herself, right? She's like, what year was that? She knows what year that was, would be my guess. And she's trying to show how far away, 6 years, now it's 2024. So again, that's the proper way to attack prior charges or convictions, which this is not a prior conviction, but a prior arrest. So she's making the argument that it was so long ago, she's not dangerous anymore.
Okay. And you're going solely off of what, the arrest affidavit? What is it that you're using to conclude due to this occurrence that was dropped, that I would not be able to be unrestrained?
Correct. Your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
But what specifically from that 2018 charge?
The fact that you were charged with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
But it was never proven, correct, because it was dropped?
It was dropped, doesn't mean it didn't happen.
Okay. I'll be working on the
And
others.
just in case you're wondering, if you have any arrests on your record, even if the charges got dropped and you get arrested or a cop shows up to your door, you better believe they're thinking you did whatever it was you were arrested for. Not all cops, but some, like this guy. It's like arrested, charges dropped, completely wrong accusation, doesn't matter. He's going to show up thinking you did it. And there was some other reason why the charges were dropped.
With the corporals and the sergeant for the supposed non-compliance. Thank you for the dates, the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence?
History is.
And you can still apply it even though it's not been.
Right, it's in your history.
Okay. Thank you for the information.
You're welcome.
Any follow-up, Dave?
No, Your Honor.
Michelle, the record for me.
So the court calls this next witness. Okay. And she's like, well, what's going on here? We don't really know what's going on. We just know the court is calling a witness. Before we get there, let me answer a couple questions. Dreamcatcher, Peter, thoughts on what will be the outcome of her motion with the media versus being in on the evidence hearing? So I don't know. It could go either way. It seems like the judge wants him out and Sarah Boone wants him out. The state doesn't care. They want him out, I guess, as well. Usually this doesn't happen in open court, so I would be okay if they block the media. If it's in open court, the media should be there. It's a public trial. Florida has very public and loose public rights, and for the public to be able to view and sit in on and watch and be a part of public hearings and trials, be a part of was maybe a stretch. But so I think that should remain open, but this is something that doesn't usually happen in open court. So I'd be fine if the judge ends up blocking media access. John, inmates can refuse to attend court. That seems not in the taxpayer's favor. So yeah, they can be charged with things. FTAs, failure to appears in Florida can be an additional crime charged. Sometimes there are things they can waive their appearance to. If they refuse and they document the record, their right to their presence at the hearing can be waived based on, what they say to an officer. And if the lawyer shows up and handles the hearing, why slow down the case and waste taxpayer money like you're saying? Joanna, Kate, do you think she should get internet access? You can limit internet access to a maximum. So maybe for some like online research or, I think she would have to allow it to be tracked, maybe not used against her what her searches are, but to make sure she's not doing anything inappropriate. There are ways you can set up guardrails. Sri, why are they twisting the law against her? I would not say anybody is twisting the law against her at all. Joanne, kind of a basic question, but do they normally have an itinerary for court dates? If so, why did they not have it? So they tell you what you're doing at this hearing in the notice of hearing. But usually you file motion, objection, or response, and then reply, witnesses that might be called. So everybody's kind of on the same page and knows what's happening based on the written documents. If she could afford to hire her own attorney, would she be allowed to have one? Yes. She's forfeited her right to appointed counsel. She can absolutely hire an attorney. I assume not, but I can't remember what was discussed. Thumbs up or down, answer is fine. So you don't have to pause. Oh, sorry. I wanted to pause and answer. It was a good question. John, in some states, you can get arrests erased from your record after 8 to 10 years. Would those still come up when a person's record is pulled? So you can get things sealed, you can get things expunged, but I will tell you, government jobs, background checks, law enforcement, a lot of times people can still find those arrests. Now, she'd be able to argue that was sealed or that was expunged. And in Florida, we do have those processes, but if the cop wants to use it against her, he can use it against her. Jackie's asking about the Tiffany Haynard case. Seems like it should be a good one. Let me know if you guys are interested in that case. Catherine said she did this to someone she does not deserve fair. So Catherine, the great thing about America is that even if a lot of people, most people, everyone believes somebody committed a crime, until it's proven in a court of law beyond a reasonable doubt, they are still presumed innocent. And why this is so great is 2 reasons. There's a lot of reasons. 2 reasons I'm going to bring up. Number 1, if they did it and we're sure, we can be absolutely sure once they're convicted, and we can feel good about that process and confident that justice was served. But number 2, if you didn't do it and you're wrongfully accused, we want to give you fair. Everybody deserves fair because innocent people must have a fair trial. And so should guilty people, because we don't know until we see the outcome. And that's why it's so important, because just like the Franklin quote we've always talked about, it's better 100 guilty people go free than 1 innocent person perish or get thrown in prison. All right, let's keep listening and figure out why the court called this witness.
Not your date of birth. Sorry, could you spell your name for the record?
CHADBARNETT.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm the deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called a stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
Stun cuff is an electronic device that's wireless.
So he has brought this cop here to discuss a stun cuff, what it is, how it works. Why do we think the court's doing this?
It's box secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's tool strapped along the calf of either leg. It can be hidden in the pants, and gives it
Stun cuff on the calf, hidden in pants, however many volts to shock somebody. And somebody, a law enforcement officer, will have the ability to do that in the controls.
people to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There is a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of use of the device. It's a 2-step process, so there is no way for it to accidentally be set off. It has to be hit 2 separate buttons, so there's no accidents. If it had to be used, it would cause a shock to the location on the calf, causing great amount of pain, causing the defendant most likely to fall to the ground.
If it gets turned on, causes the defendant a great deal of pain and most likely to fall to the ground. Why is it important that he explains this in this detail? Again, a very smart judge, laying the record, making sure everybody knows what's going on. The reason you have to have this cop describe this is obviously, number one, telling the public maybe what it looks like, explaining to the state and everybody else how this is still going to be safety precaution. They're still going to have her limited, but they're going to balance it and allow her to have her hands free and maybe even walk if she needs to or wants to, if the court allows her to. This is the best of both worlds and balancing it. But she, the defendant, we don't want her to come sue law enforcement or the government or the state of Florida if she gets injured because she gets shocked. So she has to understand the risks. He's explaining the risks. They also explain them in writing, and she's got to sign off on it that she's okay with the shock collar. Not collar. Is that what they called it? Shock collar? That's for dogs. I can't remember. Shock strap. My main mind is blanking. But she's got to sign a waiver saying, I understand that I could get hurt with this if I, of course, disobey the law or disobey the rules of the courtroom. And if I am, I could get hurt. And I'm not going to sue anybody if I get hurt because of this.
And we can secure it and take care of the situation.
Are there any other protocols or standard operating procedures regarding the use of the stun belt, other than what you've already identified?
Just to follow the response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight.
They can shock her really bad, not so bad, mid bad, depending on her actions.
We would use it to match that level of resistance.
What is
So Art and Grace, usually that would be a mistrial. If she has to get shocked in the middle of trial, that usually would end in a mistrial.
the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it's at a level 3.
And what is a level 3?
Level 3 would be failing to follow directions and stuff like that. If we asked her to get on a move or not, or follow off order, we could use it. Most likely in the courtroom, we would use it probably at a 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, Your Honor.
Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of the leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts, and you take it off as court at time we exit the courtroom. It takes a few moments besides signing the waiver and securing it to the leg.
And it's a one-time waiver?
Each day you have to sign the waiver.
Okay, and so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply
Yes,
and remove?
yes.
Thank you.
Any follow-up?
Not going to say.
All right.
Sorry.
Sorry.
Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were wearing a leg iron, your hands would be completely free. The stun cuff, same thing.
And then I would be able to walk?
You will be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank
All
you.
right, thank you, sir. State, any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
She's like, why was he called?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option.
Yes.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing.
She doesn't realize she's winning the hearing, right? Because again, she has no experience. She doesn't know what's reasonable. And the judge is providing that option because that's what he's going with. That's what he's going to offer to her. But she's like, do I still need to provide more evidence to make sure I win this motion, to make sure I can get uncuffed? And they're going to have a little back and forth discussion here.
Legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the local court has to consider with regard to your request and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move.
That's not what you said in your motion. And we read that and I was like, I'd be okay with uncuffed, shackled. She can probably stay shackled. Stun cuff is also fine as well, so that they can limit her movement and she doesn't have just free reign, but absolutely uncuffed. You can't possibly, but she wouldn't know that, of course, right? Because she's never handled this.
Properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification. Because when I read your motion, you asked to be unshackled, to have freedom of movement.
So why does that happen, right? She wrote the motion. How does she not understand that that's what she's asking for? Well, most criminal defendants that represent themselves copy and paste, even if it's handwriting. Cases they read in a book or read online or read in a law library, somebody else's motion that they get their hands on, a sample motion, and they just copy it verbatim because they don't know what's important and what's not important. And my guess is whatever motion she was copying or using, whatever case she was using, that's the verbiage they used. Unshackled and uncuffed, freedom to move about the courtroom, things like that. So my guess is that she was copying that verbiage, maybe not fully understanding what she was asking for because she really only cared about getting uncuffed. But she did. So it's all in there. So that's what the judge, being a good judge, was trying to consider in giving her options that make that available.
And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. But you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable.
Judge is 100% right. And we did the same thing. And, when we reviewed the motion and discussed it.
Freedom to move, to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks,
They always take the cuffs off for trial, right? She might not know that, but more importantly for her is in all these hearings and motions, that's when they're going to have to do it because she has to be able to represent herself and write things and take notes and things like that.
to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom. I took that as
Yeah, anybody that thinks she's insufferable representing herself was not around when we covered Daryl Brooks, I don't think.
you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify before me now at this time, you can as to what it is that you're asking of me.
Yes, handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's
Like a true lawyer, she's like, well, yes, actually, I did mean unshackled as well, because I knew at some point I would have to move about the courtroom. So she kind of, adapts her argument like any lawyer would. And so she's trying to say, I was just trying to be ahead of the curve. So let's get down to it. What is it going to look like?
what my option is because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
Go ahead.
it's just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all on the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So again, that was why I was trying to be transparent and up forward by doing so now to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from
Say yes to everything. Take everything they're giving you, because ask for the freedom of movement. If you don't want it, you don't have to use it. Just sit at the counsel table if you want to, but just ask for everything, obviously.
seeing other trials, the state and the
So she has seen other trials, so she absolutely should know what sustained means.
defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial. Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff,
She's just repeating herself.
I would sign the waiver now, just whatever.
She's like, I'm in. Give me the stun cuff. I'm in. I'll sign a waiver now. Most would. And I would too if I was her. Because especially if I'm not going to try to run or hurt anybody. It's like, whatever. Let me move around. No shackles, no cuffs.
It is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at the counsel table to question witnesses?
So these are some of the logistic things we talked about, how they've happened in other cases where it's like they both just have to argue from counsel table, openings, closings. Somebody else brings the evidence up. So they're going to just kind of go through those details that we've talked about over the last couple videos. We knew they would get here. You always have to deal with these logistics before trial. So we'll listen to them kind of go back and forth about it. Then I'm going to answer a couple questions.
How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles?
So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being.
It's like any other discussions, like it's unfair you're making me represent myself. We get it. And she's going to do that. My guess would be every chance she gets to talk to this judge.
Handcuffed to be able to progressively.
Also, very clearly, she's not picking up on that she's winning. So she's just going to keep doubling and tripling down and saying unnecessary things.
To actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am,
It's like she doesn't even know what's normal. Janet asked, will she be in street clothes? No, or yes, she'll be in street clothes. Yes, that's going to happen. They talk about that at the end, and she's going to get with somebody at the public defender's office to provide clothes for her. Sad. She has literally nobody on the outside. It seems like that'll provide clothes for her. Maybe she does, but she's going to talk to the public defender's office. So yes, she doesn't even know what's normal. Cuffs are not going to be normal at trial, but at hearings they would have been. So I think it was still a good motion for her to file and win. And then being unshackled at trial is a win for her as well. Street clothes is going to happen.
the defendants have leg shackles that, as Deputy Lowen identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed, just to simply take notes and function normally and equally, just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. Jay?
No, you're just address all the concerns, which is the court's plan.
Case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder. And there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder was representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's...
So the great thing about law is you don't have to be a genius. You just got to research, see if there's a similar case. He found a similar one, but even one step more higher crime that person was charged with, and he was granted moving around the courtroom. No outburst or physical issues in the courtroom in all the hearings and all the years that she's been there. She's never tried anything or done anything like that. Maybe verbally, annoying or whatever, or lawyers not liking her, but never physically abusive, never threats, even to the lawyers that she hated or got rid of. So again, using all that, applying it to the case law that he found, he makes the right decision.
Utilization of a stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun, given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up in court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from
He's like, I'm not seeing how anything you guys argued really changes with the Weaver case that you guys should know about. Boone doesn't know about, but you guys should know about it. Come on.
the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address the motions first. State, any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the
Now they don't have an objection anymore. They're like, before they were like, you know, she got to do this, got to do that. And now she can sit right next to us. It's like, yeah, that's fair. That's fair.
sheriff's office, who's in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect. Thank you. All right.
Good for him. That's the right answer. Kudos.
So now the court's going to grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table. Okay, you may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you, and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the council's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs.
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right.
Pretty big win for her, right? She wins the biggest motion and biggest part here that she is filed. YouTube bad actors. She should have just admitted she was drunk, right? That would help her get a lesser included charge. I don't think it'd help her walk away scot-free. Pesky pirouette. Peter, do they spend much time in law school training future attorneys about personality disorders they might encounter that are in the DSMV? Absolutely zero, zip, zilch, nada. They do not teach enough about how to deal with clients, how to deal with employees, how to deal with the business side, how to deal with mental health issues, how to deal with rejection or losing, things like that. Just there's not anywhere near enough of that. Will pro se work in her favor with the jury, and will they know why? Stop by and say hi for a break and a laugh sometime. Here's what I will say. The jury will not know why. And if she does a good job and is respectful and kind, it may work in her favor. But if she gets snappy or manipulative or condescending, it will flip quick. Nina, Peter, can a pro se testify how without direct? She just basically takes the stand, tells her story. It's basically a narrative, and then the state can cross-examine her. Alicia, why are defendants treated so differently per state? A suspected quadruple M in Idaho is always uncuffed in court. Maybe I don't know how that all happened, but maybe his lawyer asked for it. Maybe that's normal there. It's not just within or in different states. Different judges sometimes treat criminal defendants so differently. So it's not just different state. It can be different jurisdictions, and even within those jurisdictions, different judges. Michelle, if they limit her movement in the courtroom, they would have to limit the movement of the prosecutors, right? Yes. It's got to be fair. They got to make it look even. They got to make it not look like somebody's incarcerated and cuffed. Tiffany Haynard, Superman equals Supermayor. Nate, the lawyer, can catch you up. It's wild. Okay. If enough of you guys ask about that, I will have to check out his videos. I know he does great like synopsis and summaries. So I'm sure I can catch up quick and easy.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up.
They want to clarify so Boone knows you don't have leg restraints now. You will when you get uncuffed. You're uncuffed, so it allow you to write and do things and represent yourself, but you'll still be leg restrained because you're still, of course, incarcerated. And during hearings, there's no jury here, so your legs will still be restrained. You'll still be in your prison outfit. all that will change with the stun cuff and stuff for trial.
From the deputy in the back, if that's the case. Is that the standard operating procedure, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because
And they don't want her fighting with bailiffs or law enforcement. Like, I never put on these. The judge said I'm unshackled and uncuffed. They're like, just to be clear, we want to clarify everything, make sure everybody's on the same page, make sure everybody understands, especially Sarah Boone.
it's just you and me and the state, and no jurors will see that. Yes,
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with the belly chains and all that. We can take those off.
In advance.
Up here.
Yeah, I understand that. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. And if identified by Sergeant Barnett, you're going to have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to
It
be?
is under your clothing, as Sergeant Barnett identified. I have a representative from the public defender's office who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes,
Okay?
thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that I saw the confusion based on my experience and how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial,
And this is the logistics they're talking about here.
we'll address the box, for lack of a better word, for where you'll be able to go and not go. And I'm going to give the same limitations to the state. Okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you could do it or I was going to have the deputies do it. So, ma'am, I envision that because you're going to be able to move about freely and our jurors are not going to know that you have any restraints on you and they're not going to be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you, okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand, and you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy, or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I've spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the courtroom so that there will be.
Here's they're talking about additional security in the courtroom to help with the moving of exhibits. And Sarah Boone and the prosecutors will both use the same procedures. They'll hand a document to the bailiff. Bailiff will bring it to a witness. Bailiff will bring it to the clerk. All the moving or most of the moving is going to be done by the bailiff, but they're going to do it the same, which is fair. And it'll look the same to the jury. And if a jury's never been on a jury before, then they won't notice the difference. If they have, they must just be like, oh, the judge does things differently in this courtroom. It shouldn't trigger them that anything different or weird is going on.
A deputy for basically your disposal will be seated closer to you, so that if you have a document that you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please. Thank you.
That's what I'm endeavoring to try to do for you.
Yes, thank you.
Okay. Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
Thank you.
State, anything to clarify?
No, you're not.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024, a representative from the Orange County Jail cell email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of a laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today. Is there anything else, state, that we need to address?
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Yes, ma'am.
In regards to the status report you were just speaking about regarding them providing me with a laptop each day, what is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also
He's like, you were here for that.
mailed to you on, I believe, the 30th. at the appropriate PO box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, my concern was they're not stating what it was that I looked at for how long and
I don't know that
anything.
they're going to record that information on the protocol, ma'am. It's just simply when it's checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence. And I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning. And that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's at paragraph 5. The state's physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. at courtroom 12A, Orange County Courthouse, and the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question though was, are you still trying to decide or research having the media?
Media, yes, ma'am. I pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required.
And I love it. I love that he does that. I think he did it with this. He came to the right conclusion. I'm sure he'll come to the right conclusion with that one as well. It's almost like this guy knows at this point, he's got to research and he's got to make the right decision regardless of what these two sides are arguing, because it's not a fair battle in these arguments.
I know that we have a...
And what I also like is he doesn't really care if the defense doesn't make the right argument, because if the argument exists and it's the right call to rule in favor of the defense, he's going to rule in favor of the defense based on his research and if he thinks that's the right legal decision. In some cases, you don't make an argument, you waive it, the judge makes the call based on whatever. They should always make the fair and just decision. He's clearly doing that regardless of what Sarah Boone argues.
Hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th.
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing,
14th. So we're going to have another hearing in 2 days. So hopefully on the 14th, that Wednesday or Thursday, we'll be covering it here together.
are we able to have a copy of it prior?
Sure. I don't see any problem. It's the Miami Herald decision. I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank
And
you.
that will be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me. It's
So again, they're talking about objecting to the evidence that the state's going to enter. She's got to make sure she does that ASAP. She's going to clarify here, but it's interesting. He's going to keep reminding her of this stuff. Like, I'm going to remind you to hit the like button and subscribe to our channel, because we will keep covering this case. It's moving fast and furious towards an October trial date. And I think it's going to either go in October or very shortly after. So we're going to be in on this.
objections for the
The
evidence from
digital
the state
evidence, the digital evidence only.
of the 2 USB drives from Mr. Lane.
No, ma'am, the USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days, and I have to write objections.
That is correct. So your objections to the digital discovery will be due no later than August 23rd.
What's great about this Lissalot is that she can make her objections, make her arguments. Judge makes the call, sustain or overruled, and we move on. It's not endless circular arguments.
And I will put this all in order for you as well, ma'am.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No, Your Honor.
Ma'am, is there anything else?
I do have this. I made a copy of it for you this letter that I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags, and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet. If I could be supplied earphones and headphones for listening, and a word program, just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drive.
I think some of that could potentially be reasonable with guardrails. We will see what the judge ends up deciding.
And just, as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Ma'am, well, you could give your letter to the deputy. We will file that in the court file. Part of the reason we just set the August 14th hearing on your motion for the hard copy discovery was that Captain Di Giovanni was returning on August the 12th from a vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on media request or prevent media from being at the September 3rd discovery viewing hearing will address your concerns as identified in this letter and have a representative from the jail, be it Captain Di Giovanni or someone else here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded, inspecting and testing and photographing, I believe that is my business only, and one privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence hearing, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
No.
Okay. I will see you all on August 14th at 1:30. Oh, thank you. Ma'am, as the attorney from the Justice Administration had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Barrios also send you a copy by way of mail. It was already mailed. Okay, we're going to mail you a copy as well now. Today, I'm going to give this to the deputy to provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
Yes, thank you. And then also the public defender's officer said would be meeting me downstairs.
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Glick. All right, any other questions, Dave?
No, Your Honor.
Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail.
Thank you.
All right. August 14th at 1:30 is the next one we will watch together. In Florida, the attorneys have an agreed number of strikes for jurors, so it's codified in the rules. It's either 6 or 10, depending on what her possible sentence is. I'll have to do more research on all of that before it actually starts, but it'll either be 6 or 10 unless they agree to a different number. Plus, they get one for alternate jurors as well. Just that girl. Will other pro se defendants have access to laptops, et cetera, since she's been given these privileges? Do these orders change privileges others get? So it doesn't necessarily set a precedent. It's judge to judge, and it's case to case depending on the defendant's background, what they ask for, how they ask for it, what accommodations the jail can make. There's all sorts of different things that go into it, but it's basically a case by case basis. This is kind of the norm, though. If it's reasonable, if it's necessary, we want them to do it. We want them to be allowed to do it because we want a fair trial. We want to give them the best shot they possibly can have. All right, I got to get to my 4:30 appointment here. Perfect timing. Hit that like button. Subscribe to our page. That's all we've got for today. Until next time, I'm out of here. Let me know in the comments. What's next? What do you want to see? What other cases are you following and watching? Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.